Now we'll talk about the real people that practice law around here. We have Elliott Hahn. We have Dora de la Rosa. We have Jeff Lewis and Robert Morrow. We're going to go through some common questions that have been asked seem common through all of us, and then afterwards we'll have some time for a few questions from the audience, and then absolutely afterwards, everyone will be here to ask any questions you might have. And Elliott, I'm going to ask you first. Somebody walks into your office and says, I'm thinking of starting a business. What type of formation or formation options are best for me? How would you answer that, Elliott?
Well, the answer is, of course, from a lawyer's point of view, it depends. There are various ways to do business. One, you can be a sole proprietor. The problem with that, the advantage of that is you get all the money. The disadvantage is you have total liability. Something goes wrong, somebody could sue your house, your estate, your retirement fund, etc. The second way is you can form a partnership with someone else. You can form a general partnership, you can have a limited partnership. The advantage of that is, first of all, there are tax advantages to doing that. The disadvantage is that the partnership can have liability and you have a partner. The third way, which is the most common way today in California, is you form what's called a corporation or an LLC, limited liability company. The corporation, the advantage is that your liability is limited to your investment. So no matter how bad things go, the most you can lose is what you put in. The disadvantage is you have a board, you have shareholders, you have responsibilities. And you might give someone one share. You might have 1,000 shares. They, as a minority shareholder, have enormous protection under California law. And with what's called a limited liability company, which is similar. There are tax advantages to doing that if you think you're going to make money, but you don't have some of the protections of a corporation.
Okay, but that brings me to now, Jeff, because you brought up, or actually to Rob, that you brought up the tax issues. Rob, you want to weigh in a little bit?
The first option as a sole proprietor means that there isn't a separate entity doing the business. So instead, the income, the profits of the business is taxed right on the owner's tax return itself. That can be okay if you're getting all the money, so you get all the income too. If you form one of these other entities, though, a corporation is its own taxpayer. So if the corporation has a profit, the corporation pays tax on it, not its shareholders. In order for the shareholders to get that money, the corporation has to pay the money to them. And we all know that that's a dividend. So that's how corporations are taxed twice. So a corporation can be an inefficient way of running your business because the money gets trapped inside the corporation. You can't get it out without taxing it again. LLCs, as my colleague mentions, are tax advantaged because LLCs are not taxed. Instead, if the LLC shows a profit, the owners of the LLC take that as their personal income and pay tax on it themselves. The trade-off is that the corp or the LLC can now pay the cash out to the owner, and there isn't a second level of tax. There's no dividend from an LLC. So you get, with an LLC, you get the limited liability protection similar to a corporation, but the income is only taxed once, only as it's earned to the LLC. And I think later we're going to get into phantom income, and you know, when we get to that, you'll see sometimes LLCs can surprise us with phantom income. And one last thing real quick is you can also make an election if you're a corporation to be an S corporation. S corporations are corporations in all respects, except they skip the first level of income. There's no corporate tax imposed on an S corporation. Instead, the income passes through, the shareholders recognize it themselves. So similar to an LLC is in terms of being a pass-through entity. So if you're going to have a lot of profits, it can be inefficient to have it in a C Corp. You'd rather pass it through. I have an issue right now with a client who owns an interest in a movie. A studio has come and made an offer on the whole movie. The problem is she's owned this movie inside of a C corporation for 25 years. So it's inside the C. The problem is if she sells them the movie, the C corporation is going to have a huge profit. That's going to be taxed. In order to get that money out of the corporation so that she can use it, she'll have to have a huge dividend taxed again. So that's our problem, right? It's The C corporation has served her well for a few decades, but now at the end game, it's a problem. She can't get the cash out. Unless she sells, rather than the movie, sells the buyer the corporation. She can just sell the stock of the corporation. Now it's the buyer's problem. He's got a C corporation with an asset stuck inside of it.
But let's keep moving on the same topic of, you're setting up a corporation and now you've decided that you want to lease a building and, the contract with the landlord says there's an arbitration clause and a mediation clause. What's the difference between the two, and should I sign it? And you know what? I'm going to look to you, Jeff, to get your perspective on that one.
Okay. Arbitration and mediation are alternatives to traditional litigation. If a business has a problem and they need to solve their dispute in court, traditionally you file a lawsuit and a year and a half, 2 years later, a judge or a jury resolves your issue. And if there was a mistake made by the judge or the jury, you can go up on appeal and hopefully win a reversal. That's the traditional model of litigation. Arbitration and mediation are alternatives. They are a private process. Parties agree to hire a retired judge or a well-respected attorney to sit in a room, hear the evidence informally, and give a final binding decision. Right or wrong, that's the end of the case, and there's no appeal. I generally, as an appellate lawyer, don't like to encourage people to do arbitration because if there's a mistake made, you've signed away your rights to seek further review. But if you're a client that is interested, if you're a business that's interested in quick resolution of disputes, finality, and privacy, perhaps there's matters you don't want in the public record, arbitration might be the way to go. But generally, I do not recommend people sign arbitration agreements. Mediation, on the other hand, is another form of alternative dispute resolution where parties can agree to hire a private judge or a well-respected attorney to talk the parties into settling a case. It's completely voluntary. You don't have to accept the settlement. Either party can end the process at any time. But sometimes at the very beginning of a case, before the lawyers have charged a lot of money, before emotions run high, there's a solution to be had where a settlement can be carved out. And I always encourage people either to go to mediation or include a mediation clause in a contract. But arbitration clauses, unless you're interested in privacy or expediency, I encourage people not to include arbitration clauses.
Does anybody else want to say anything on, because I agree with everything you've just said, so I can't say it any better. Anybody else? All right. Well, let's keep going on with the idea of, leasing space. And, one question that's come up is I need to lease space for my business, and the potential landlord wants me to sign a license rather than a lease. Which is better? Dora, with your real estate experience?
One thing that I did discover when I returned was the increased popularity of licenses for space. You don't typically think of licenses as something that people use as alternatives to leases. So they are alternatives to leases. The interesting thing is just, you always have to just consider what the goal is. Licenses, the difference between a license and a lease is typically for a longer term, and it grants an exclusive right to use a space. So if you lease if I were to lease this room, this would be my space for the duration of that term. Someone else could not come in and occupy it. That's my space. Usually it's for a specific term, a longer term. It is not revocable. It's mine for that period of time. But I could generally transfer it. So it's something that I own that I could transfer. A license, on the other hand, is permission to use an area. It's not exclusive. Maybe typically it's, for instance, kiosks at a mall or storage space in a larger facility. So you have permission. It's revocable at any time, generally. So it's a short-term thing. So the advantages of a license are if you only want something for a short period of time, you don't want to be bound, you don't want to be stuck, you don't want long-term liability, a license might be the way to go. And so the key is just that just calling it a license or a lease is not going to do the trick. The characteristics have to be defined. So it's just important to make sure that you've outlined in the body of the agreement those characteristics. Don't just rely on the fact that it says license versus lease on the title.
Okay. That's a good thing to keep in mind nowadays. Would you like to say something? Weigh in, Elliott?
Yeah, I would like to take a different issue, and that is our firm is a general business firm. We do a lot of lease negotiation, usually for tenants. A lot of our clients are foreign companies, and they believe the landlord gives them a form, and they believe that they should therefore sign the form because the landlord tells them this is the typical form that everyone signs. First of all, what anyone else does, I always tell my client, I don't really care, frankly, what anyone else does. Second of all, that form is done by a landlord-heavy association, so they don't sit there and figure out what's best for the tenant. So we tell our clients all the time, first of all, seriously, everything is negotiable, everything. And second of all, if you don't ask for it, you're not going to get it. So don't negotiate against yourself, first of all. And second of all, sit there and say, what do I want? And let's see that I can get that. I mean, we have a Japanese company. They're a very good client. They're a very big company. But they told the landlord during the negotiations they were moving things in the following week. That's like the kiss of death, because that tells the landlord, you're going to sign a lease with me, and you have to sign it right away. So a lot of times we tell our clients, first of all, let the lawyer talk. Because the landlord, no matter how much he thinks says he's your friend, he's not your friend. Okay? So let the lawyer be the bad guy. That's what he's paid to do. But let him talk. Second of all, make sure that everything is in writing. And third, because in California we have what's called the parole evidence rule, which means that sometimes oral negotiations are admissible, but not in a real estate contract. And third, make sure that you're getting what you want and you read what's called the boilerplate. One of the lawyer's most important jobs is, a lot of the lease is like 50 pages. And believe me, if you have a problem sleeping, just pick up one of those leases. Within 5 minutes, you'll be asleep. But the most important parts are often pages 30 to 50, where they talk about boilerplates. For example, how many days late can you be on rent? What happens if you are late the first time? You don't want that to be a default. You want what's called a grace period. And second of all, the landlord, especially today in common areas, has what they call landlord rules. That is, there's a common area and they have rules. You want to know about those rules. You also want to know landlords look to what are called triple net leases today, which means they want the tenant to pay everything. Well, that's often not fair to the tenant. So let the lawyer do his job, but read everything carefully.
Now you have a vendor. Now we've gone to the lease. Now we've got a vendor. And the vendor's lease has an attorney's fee clause in it. Should I sign it? Jeff?
Oh, that's a good question. I get asked this a lot. Generally, my advice is yes. You want to include an attorney's fees clause. Having an attorney's fees clause in a contract ensures that weak or frivolous claims will not be brought against you without some consideration by the other side that at the end of the case, they will be liable for bringing a weak claim. The general, whoa, there's a little feedback there. The general rule in California and most of the United States is when you file a lawsuit, you pay your lawyer, and even if you win the case, unless an exception applies, you are responsible for your own lawyer's fees. So you could go to trial and win $50,000 in damages, but still have to pay your own lawyer $100,000, and it's a net loss of $50,000 to you, unless there's a statute or a contract that has a provision for attorney's fees. And so that's why most of the time I advise my clients to have an attorney's fees clause. And if someone gets hit with a lawsuit where there's exposure, it encourages settlement early on, which is also usually in a client's best interest if it's a weak case for that particular client. So the short answer is yes, sign that contract.
And it doesn't matter if it just says it's for, say, the landlord, it becomes mutual whether or not it says it.
Absolutely.
One way or the other.
In California, frequently lenders and landlords will have forms that say if the landlord prevails in an eviction or if a lender prevails in a foreclosure proceeding, the lender will recover attorney's fees. California has a statute that makes it reciprocal so that both sides can take advantage of that attorney's fees clause.
Buy-sell agreements. Where do they fit in and why are they needed? And when do you need to establish this agreement for when you're forming the corporation? And I'll go to you with that, Elliott.
Well, buy-sell is a very important topic in contracts. What a buy-sell means is it's a provision, it's an agreement between parties to a corporation or parties to a limited partnership or parties to an LLC that talks about what happens in effect if one person wants out. It's very important that this be discussed in the beginning. You know, usually when two people come to you and they want to form a corporation or some kind of legal entity, that's sort of the marriage period, if you will. They love each other. They can't imagine that there's going to be a problem. Well, the law is just like the state of California. 50% of marriages in California are divorce. Same thing in law. There's going to be a problem down the road. If you don't iron it out in the beginning, you're going to have more problems down the road. So the buy-sell talks about, let's say that Rob and I form a company, and we're doing well. Always in these cases, you think about if you're doing well. And a year down the road, Shelley comes to me and says, you know, I want to buy into this company and I want to buy your interest and I want to sell. Rob hates Shelley. No offense. Okay? So what happens? The buy-sell talks about exactly that kind of circumstance. Usually in the buy-sell you provide that if a party wants to sell to a third party, first the company or the shareholders, whatever it is, or both, have the right to match that kind of offer. That's very important because that way I can, if I'm the shareholder with Rob, I can prevent someone coming in and buying an interest and I don't like that person or we have different aims or something like that. As I mentioned earlier, California is very protective of minority shareholders and gives them enormous rights. So you might say, well, what happens if he only sells one share? That shareholder now has enormous rights. They have right to financial statements, they have right to see the books, they have right to audit the books, etc. So you want to talk about the buy-sell in this regard. Now, sometimes what you do in the buy-sell is you're worried. What happens if the company doesn't have enough money? Shelley comes in and says, I want to buy the interest. So the buy-sell can provide that first, if I buy the shares, they have to be offered first to the shareholder. I have a right to buy them over time. Maybe over 2 years is common today in California. Or even it says it doesn't matter. If I want to buy the shares, it doesn't matter what the third party is offered. Rather, you have an accountant go in and look at the books and decide what should I pay. The reason you do that is you're afraid, for the sake of argument, let's say that Rob and I form a company and Time Warner comes in 6 months later and says, wow, this is a fantastic deal. We'll just buy out the interest. I don't want to sell. But they've offered so much money to Rob that I can't match that offer. I just don't have the funds. Now I'm trapped in a situation where I have a shareholder with me who doesn't have my interests, doesn't have my priorities, and may have a totally different way of looking at things. Also, the buy-sell also applies, interestingly enough, in California. You have what are called spousal waivers. Because if I start a company with Rob and he's married, his wife owns, under community property laws, usually 50% of his interest. Now, for the sake of argument, what happens if they get divorced? She's an angry, for the sake of my hypothetical spouse, and now she's my shareholder at the same time. So she wants to, for want of a better term, hurt him as much as possible, and she might want to run the company in the ground. So you often have what are called spousal waivers.
Well, dealing with governmental entities, usually in the real estate context, you have land use issues, and it's a very arcane area of law. So I guess my number one suggestion is make sure you have somebody who's got some experience dealing with land use issues in those particular areas, because it can be a very narrow area, and also somebody local to the area that you're dealing with, because each municipality, governmental entity can pass their own statute and have very local specific statutes. But in general, I guess one thing I want to say is it's a good idea, even before you have issues that will arise, to be an active member of your local community. Be involved in your chamber, be involved in the local rotaries and whatnot, because so much of land use law and dealing with governmental entities is relationships. And private enterprises, private companies are usually goal-oriented, but public sector is usually process-oriented, because they have to make sure that everything is done properly and according to process. So you have to remember that you're coming from two different perspectives. But certainly having those good relationships right off the bat is very important. I see Dennis McLean's in the audience, and he's high-level Rancho Palos Verdes, a director of technology and finance. So having a great relationship with somebody who's can help you shepherd through that process is very important. So I would say that's one of the key tips. The other thing is to do your due diligence. Make sure you research the statutes that are involved, if there's any local political issue that might be relevant to your particular matter, make sure you're aware of that. But those in general are tips.
Okay. Anybody else dealing with government agencies?
We do a lot of employment law in our firm. And unfortunately, the fact is today in California, many times when an employee leaves, that employee immediately decides that he or she has been harassed or has been discriminated against. They file a complaint with the state of California. A lot of our clients, they get a form from the state of California. It looks pretty obvious on its face that you just write it up and send it back. That's a huge mistake today. The first thing is, if you have an employee and the employee isn't doing well, document it to the nth degree.
Now, let's talk about when, you owe taxes, but the bank account's empty. What do you do now?
A client will often say, how could I possibly owe taxes when I don't have any money, right? And the point is that your income, right, the 16th Amendment to the Constitution taxes your net income, but that means some things aren't deductible, right? So you can't deduct your car, you can't deduct your food. So you might have spent that money on these other things, right? So you don't have the money left over in your bank account, but you still have income. And so it's still taxable. Now, that's not the same thing as phantom income. Phantom income, rather, is where you have an entity, like an LLC or an S-corporation, that itself is profitable. When it has a profit, remember, it doesn't pay tax. Only corporations do. S-corporations, partnerships, LLCs, they don't. Instead, they pass the income through to the owner, and the owner pays tax on it. Now, notice, the owner hasn't received any money. Right? The point is that the entity, the LLC or the corporation itself, was the one that was profitable and it has the money. So there's a famous case by a guy named Knott. He owned about less than a quarter of a corporation, and he got a huge tax bill. And he went to court and said, how could I possibly owe any taxes? The corporation never gave me a dime. And that's because he was a minority owner in an S-corporation. The S-corporation itself was profitable. He owned about a quarter of the S-corporation, so he had to pay tax on about a quarter of its profits, whether it was paid to him or not. To make his situation even worse, notice that he only owns a quarter of the corporation, so he can't even cause it to distribute him money. This can be a nasty way to freeze out a guy you don't like, right? Shareholder in your corporation, he's paying tax on his share, but you haven't paid him any money. But if you're in Mr. Knott's position, that can be pretty nasty. So that's phantom income. It's where either you've spent the money on things that aren't deductible, so that's why your bank account's empty, but you still have income. Or you have one of these business entities which gladly, happily is making a profit, but it's passing it through to you without actually paying you any cash.
All right. How about this one, Jeff? Starting a new job and the contract has a non-compete in it, is it enforceable?
The short answer is most often not. Typically, at the end of an employment relationship, somebody wants to go out and either start their own business or go work for a competitor. And most employment agreements out there have a clause in there that say you can't go work for a competitor or compete with us. In California, we have a strong public policy that you should be able to work for whoever you want. And those provisions are generally not enforceable unless you talk about an employee who's also an owner of a company and he's selling an interest, or you have a partnership that's dissolving. But in the typical employer-employee relationship, covenants not to compete are completely unenforceable, and you're free to go work for whoever you want. That's not to say once you get to your new employer or you start your own business, you're allowed to use confidential information you've acquired while on the job at your old employment. You have to be very careful to start fresh, use your own work product, and not take the fruits of your former employer to your new business.
This one?
From a company point of view, it's very important to figure out, if you have a new employee, what kind of trade secrets or proprietary information will that employee learn. The law is clear. You can restrict that person's ability to use or even circumscribe that person's ability to use that information later. Second, you also can, in writing, have them agree that they won't solicit your own employees, that is, pirate them for the new company. So it's important that you have a carefully defined agreement as to what are they going to learn, how is that a trade secret, and they acknowledge. And just in fact, today we have a client that had someone leave that they are afraid of, and so we wrote a letter to the new employer and enclosed a copy of the prior trade secret agreement and said, if this agreement is breached while this person works for you, we're going to look to you for liability as well. So that can be a powerful weapon.
Very good. Now, Jeff, what happens if they now sign this contract on their iPad, not with a, on an iPad, not with a pen? Any Any problems with that?
You know, that's a frequent question. People doing business on iPads. Are an electronic signature, is an electronic signature the same as an original blue ink signature? And the answer is yes. Courts in California treat electronic signatures the same as a blue ink signature. There's a few exceptions, trusts, wills, real estate documents, some documents you submit to the government. But generally speaking, two parties to a contract that are doing a private deal, all things being equal, a electronic signature signed on a iPad is as good as a blue ink signature.
There are also a lot of agreements today that provide that fax signatures are acceptable. So that's a common means of doing business today.
All right. What about, Dora, you're getting ready to do a negotiation for a lease and for a commercial lease. What is negotiable in the commercial lease, and which provisions benefit a landlord versus a tenant? I mean, how do you address that with your clients now that you're doing these?
Right. Well, actually, Elliott addressed a lot of this earlier, and he's absolutely right. So a lease is simply a contract. And as Elliott said, most tenants in particular will get a lease from the landlord, and whether it's a form or it's been drafted out, but don't ask any questions and just think, okay, well, it's been given to me, it's been presented to me, I've got to sign it. And that couldn't be further from the truth. Everything on that lease is negotiable. So now, whether you have bargaining power, who has the leverage, that's another story, and typically it depends on the market. If it's if there's an excess of space available, then the tenant will have more leverage, and vice versa. So, but as Elliott said, if you don't ask, you won't know what you're going to get. So definitely approach it as that document is definitely negotiable. Some of the key things that we look at that are things that you want to look at when whether you're the landlord or the tenant, but options. If you want to be in a space for a shorter period of time, maybe you don't want to be locked in, it's probably better to go for a shorter lease period with some options. That will give you some flexibility. Assignments and subleases, those are key things to look out for, because that, again, binds you, gives you additional rights or not. You may outgrow your space and you may want to look for a new space, but what do you do with the lease you're currently in? Gives you more flexibility if you can assign or sublease, so look out for that. Maintenance and repair costs, something Elliott touched on earlier. Who's going to pay for what? So allocate the responsibility of who's going to pay for those types of things. Exclusivity clauses, if you're renting space and you're a florist, you want to make sure that your landlord can't lease the space next door to you to another florist. So you want to make sure you have those exclusive rights. Termination rights, things to look at, how much notice do you have to give, that type of thing. Subordination and non-disturbance, those are other things that a lot of people won't look at, things that Elliott referred to as boilerplate, but important things. If the landlord wants to be able to refinance that piece of property, they want you to sign an agreement that's a clause that says this lease is going to be subordinate to that future financing. Well, in exchange, you want a clause that says, okay, well, that's okay, but as long as I pay my rent, I'm not going to be disturbed. So there's some quid pro quo there. So just make sure you approach it with the attitude that your rights need to be looked at as well, and negotiate.
Well, Dora, let's look at this. What happens if somebody has they've already negotiated the lease, and there's a space that comes available next door, they want to expand. Now that bigger space is opened. What do they have to do? Do they have to sign a new lease? Can they just move in? What could they do there?
Right. So the other part of that is that once you've signed a lease, it is a binding contract. So you are technically stuck to that contract. However, this is the marketplace, and landlords generally want to fill bigger spaces because it's more rent. So one thing to keep in mind when you're negotiating your lease in the first place, one thing that we advise is if you negotiate you've heard of right of first refusal. There's right of first negotiation to an additional space. So you can build that into your lease, where if a bigger space comes available later down the road, you want the first right to be able to negotiate for that. So that's something to remember to do, hopefully before. But once you're in that lease, you talk to the landlord and you negotiate, and you can work things out. You can agree to terminate your lease early, sign a new lease. But yes, you do need to sign a new lease for that additional space.
Okay. Very good. Elliott, any comments on the leasing?
I would say two things. One is each party should know who the other party is. I mean, the reason I say that is one of our clients is a Japanese company. Every landlord wants to see a financial statement. Japanese companies don't ever want to give financial statements. They consider that sacrosanct. And it's almost insulting, frankly, to ask them for a financial statement. So you have to know each party. And the other thing I would say is, I thought Dora, her point was very good, but there's always a provision that says in the agreement that if the landlord wants, he can move you to a comparable space. It's in every lease. Well, I had a client, and the landlord came to him. He's downtown, and the landlord said, "We want to move you 3 streets over." And I said to the tenant, "Why did you sign this lease?" He said, "Because they told me they never use it." Well, they did. So don't, you know, I tell you a firm lesson I've learned. I'm old enough to say this. Don't believe anybody, especially when they're negotiating. Put it in writing.
That's one thing I always put in my leases for my one client is the landlord can't move them. Landlords will fight you on that a lot of times because they might think somebody bigger, better might come in later. But hold true to that because it can really disrupt your business if you don't.
And if you don't win on that, for instance, if it's a landlord-friendly market, at least perhaps put in there that if they are going to move you, that they have to pay all the costs and get something out of it. Don't just give in completely.
Jeff, you just signed a contract with this new day and age. We're signing things on iPads and everything else. But your contract with your web designer requires that you do not post any negative reviews on Yelp. Should you sign it?
The short answer is absolutely not. Anybody here ever post a negative Yelp review about a business? I have, plenty of times. A lot of businesses are now trying to come up with these contracts that say you waive your right to do so, you assign your copyright to any Yelp review. You just basically will agree never to post a negative review on a website about that particular business. Sometimes contractors or businesses in attempting to resolve a dispute will say, yeah, we'll come back and fix the problem, but you agree if we come back and fix it, you're going to take down that Yelp review. California's on the forefront on this problem, and in September of this year, just a couple months ago, passed a new law that says these kinds of contracts are illegal. They're illegal to even propose. You could be subjected to thousands of dollars in civil penalties. If the DA catches your eye, the DA could bring an action, or it could be a civil action. If someone goes to court and tries to enforce this by way of some sort of injunction or an action for defamation, they'll lose because these kinds of contracts are illegal. So do not sign it. Politely remind the other side they're illegal, and ask them to send you a new version of the contract that doesn't have a clause that waives your right to do a negative review.
Very good. Anybody else? How do you dissolve or leave your partnership?
Well, partnerships in particular are creatures of contract. So I tell my students a story. When I was in law school, there's these hills outside the law school, and 2 guys walk up to the top of the hill, and they shake hands, and they say, this would be a good place for a mall. As soon as their palms touched, a partnership existed between them. They don't need the permission of the government to create a partnership. A partnership simply comes into being, springs to life, as soon as 2 people agree to go into business together. Usually, they're going to enter into a written contract. They're going to write something up about the terms of their partnership. Partnership agreements will usually incorporate the buy-sell agreement we've already heard. And the buy-sell agreement usually has provisions on how you get out. That if you're talking about a partnership, hopefully you've done a little bit more than those 2 guys at the top of the hill, and you've actually written up an agreement, and it has provisions on how you get out. What I often tell my clients too is that the provisions in the contract are what you use when you can't agree, right? If the partners aren't having a good time together, they probably both want it to end, and they probably can come to terms with themselves on how to end it. If they can't, they can fall back on the agreement. One more quick story, I hope. Corporations will usually have buy-sell agreements. It's separate, then you have a separate agreement for that. But I had a case once where these 2 guys were best friends their whole lives. They were the best men in each other's weddings. They owned 50% each of an S corporation. One day, one of them noticed that his profit share was only 49.5%. He went to his partner, his best friend, and asked him where'd the other 0.5% go, and he said, well, don't you remember you gave that to me? So now he had a share certificate that said he owned 50% of the stock, but according to the tax returns, he only owned 49.5%. So they tried to work it out. They couldn't work it out. They didn't know what to do. They couldn't split up the business. They asked me what to do. The 49.5% guy did. I said, well, if your stock certificate says that you own 50%, you have a unilateral right to dissolve the corporation. You don't have to even ask his permission. So we gave him one last chance and said, you can let us out. We can do it amicably, or we're going to send the paperwork to Sacramento and we're going to dissolve the corporation ourselves. And that's what we ended up doing. And I remember the funniest thing about this was, I'm not a litigator, and kudos to Jeff, but his comrade in litigation called me very angry about this. You should be in court to resolve this. Why do I need to be in court? I've resolved it. I dissolved the corporation. We're now going to split up the assets and go our separate ways. You could have played, but you didn't. So, there's lots of ways to do it. You can fall back on the contract if you have it. If all else fails, California law will usually give you an out, and that's when California helped us here.
If I could just add something really quick. I don't form partnerships. I go to court over them. It is very easy in California to form a partnership. I had a case that went for years in litigation. Two guys in a bar had an idea for a business, and on a cocktail napkin they wrote $200,000 in, comma, profits to be split equally. And for years there was litigation. Was that just a loan, as one partner suggested, or was that a partnership? Years of litigation. So you're better off going to someone like Rob, who can form a more formal partnership agreement than a cocktail napkin.
Can you hire independent contractors to get around Obamacare and its benefits?
Well, independent contractors is an area that comes up every day. For example, if you hire a painter to do your house, and he comes to your house and he paints, what is he? He's an independent contractor. The problem is a lot of companies today want to get around giving benefits. They don't want to pay Social Security, they don't want to pay Medicare, they don't want to pay medical benefits, they don't want to give life insurance. So they call someone an independent contractor. Because an independent contractor under the law is an independent person. He's not entitled to benefits, he's not your employee. The problem is the employer and the employee do not decide if that person is an independent contractor. The IRS and the law do. And they have specific tests. So you can't just say you're an independent contractor, because that's not the law. So the law is if the person decides what hours he or she will work and brings his own materials and can do the job wherever he or she works and can work for 3 other people, say, at the same time, then the person's an independent contractor. But if the person works for you, comes to your office, uses your materials, the computer, etc., and doesn't work for anyone else, that person's an employee. It doesn't matter what you call them. There was a case about 8 years ago. This really got to be famous because Microsoft was very famous. They would hire programmers, and they would have them work for 8 or 9 months. And then they would say, you're an independent contractor. But these people turned around and they sued Microsoft. They said, we want the stock benefits we're entitled to receive, the benefits we're entitled to receive, etc. So the law also says now, even if the person works for other people, if he works 6 or more continuous months for you, he's probably an employee. So it's very dangerous then if you work with temporary agencies to say, this guy is good, Mr. Jones. Even though he's a temporary employee and he works for you, have him come every day for the next year. He's almost surely going to be deemed to be your employee. So that's an issue. So can you get around Obamacare by calling someone an independent contractor? Though, first of all, as I said earlier, it doesn't matter what you call them. The law decides. And second of all, you have to be very careful in what you do. And a second area with an independent contractor is he's learning your trade secrets, your proprietary information by working for you. Do you want him then going to somebody else and using that same information? So there are actually advantages sometimes to having the person be an employee rather than an independent contractor.
All right. Well, sticking on the employees, unless anybody else wants to weigh in on this issue, what about employee handbooks? Why do we need them, Elliott?
Employee handbooks are actually, that's one of the most important things that an employer can use today. We recommend it for every client with at least 5 employees, without exception. Why? Because it's your opportunity to put down in print what your policies are that are especially important, not just for the employee, but if there's a problem. For example, one of the things the courts look to today in sexual harassment is, do you have a procedure to report sexual harassment? Was it followed by the employee? How do you lay it out? you put it in the handbook. We talked about earlier about trade secrets and proprietary information. You put that in the handbook, things like that. So the handbook, and it should be revised every year because the law in California, you know, contracts, the law is basically the same as when Lincoln went to law school. But employment law changes dramatically from year to year. For example, an often ignored provision in employee handbooks was rest and meal periods. That's the law in California. Employee works for you, they have to get over a certain amount of time, they have to get a rest period, they have to get at least a 1-hour meal period. There was a huge case last year in California that had to do talked about meal periods. The law in California is if an employee works 5 or more hours, they must get at least a half-hour meal period. Well, the question last year in California before the California Supreme Court was, do you have to make that employee take the 30-minute period? What happens if they say, you know, I want to get out earlier, so today I'm not going to take that 30-minute rest period? Well, the law in California is it doesn't matter what the employee says, you have to give them the 30-minute period. Same thing in the handbook. What happens if an employee comes in early every day? A very famous case with a major law firm in California a couple years ago. An employee was supposed to start work at 8:30. She came in at 8 o'clock because she said her bus let her off early. She came in and sat at her desk from 8 to 8:30 and sat there and read the newspaper. And then when she left, she gave the law firm a bill for overtime for over $25,000. And the law was they had to pay it. So you should be very specific in the handbook. You are not entitled to overtime unless it's in writing. Our normal working hours are X to Y, etc. So the handbook is very important in those areas.
Anybody else on this issue? What happens, you know, you decide you want to buy a building now, Dora? You know, what are some of the things to think about?
You know, buying a building is very complicated because it involves, it's mainly an economic decision, it's got tax consequences, and but usually what it comes down to is a business owner says, you know, I've been leasing space, and rather than put money into this lease and not get anything back for it, I'm going to buy an asset, you know, buy the building and buy an asset. So definitely it's something to consider, but it's a complicated matter. You know, you want to think about location and how that impacts your business, whether it's something that, you know, a place where you want to be visible, whether you might not need to be visible, maybe you're kind of an e-commerce kind of a business, so maybe that doesn't matter. Liquidity, you're going to lose liquidity because you're going to put most of your money into this asset now. And so there are many issues to look at, but you want to have a good purchase and sale agreement that you've drawn up, make sure it's looked at. So it's actually quite complicated, encompasses many different areas, but typically it's more of an economics business decision.
Jeff, what do you think about taxes if you're going to think about buying a building?
You know, the thing about a building is just like any other capital asset, you know, property that you buy, you don't deduct the cost, right? So I buy a building for $1 million, I don't have $1 million tax deduction. Instead, I get to take those costs over a certain amount of time and deduct it over a long time. Buildings is like 30 years. So that's the biggest thing, is to consider how I'm going to, you know.
Well, let me go back to something then to Dora again on this. If, you know, buying the building, isn't it the same as just buying the house, or what's the difference there?
Right, so it's very different. So residential versus commercial. When you buy a residential, you have there are lots of, in California, lots of consumer protection laws. You don't have that in a commercial setting. So, you know, it's a transaction, it's a business transaction, it's an arm's length transaction. So you've got to be even more important to make sure you've got the right kinds of advice, a good realtor, a good attorney, a good accountant involved so that you're protected, because you don't have those statutory protections. They're usually long-term agreements that you're going to be in for a long, long time. So there are things you have to look at very specifically and very differently. And it also, everything's negotiable, as we discussed. Now, everything's negotiable in a residential agreement as well, but those tend to be more standardized, whereas your commercial has more room to vary. So get good representation, much more important in a commercial context.
Okay, well, your question is kind of has two parts to it. I want to consider incorporating somewhere else to take advantage of its laws rather than California's laws. But that's not really a tax question because taxation occurs where you earn the money. So, you know, McDonald's, I believe, is a Delaware corporation, but McDonald's has income in California, so it still pays California income tax. So if you set up your corporation in Nevada or Delaware or North Dakota or wherever, if you have California income, you pay California income tax. So that doesn't matter. That's not really why you do it. You do it because the other states, there's an old law review article that it's called The Race to the Bottom. And it's where the legislatures across the country tried to make corporate laws that were as favorable to business as possible. In other words, the worst possible corporate laws for everybody else, right? So it was the race to the bottom to give them the best, the big corporations, the best possible corporate laws. And for the longest time, Delaware won this race to the bottom. So, you know, a lot of corporations go there, set up in Delaware, because they can use its statute. And in California, we have a law that says if you're a foreign corporation and you come here and do business, you have to register to do business here. If you have income here, you have to pay tax on it. But if there's a matter of corporate law that comes up, for the most part, you get to use your state's laws. So if you're a Delaware corporation doing business in California, you get to use Delaware law for certain aspects of your corporate governance. But remember, it's not a tax issue. You pay tax where you earn the income. And of course, federal taxes doesn't matter.
Elliott, you got something to?
Most of the times, the person who asked that is going to do business only in California. But they read in the newspaper something that Nevada, for example, is very famous for having lower incorporation taxes. The problem is the Franchise Tax Board is not stupid. You have to, if you do business in California, you have to what's called qualify to do business. And the definition of doing business, frankly, becomes more expansive every year according to the state. Illinois, for example, is very tough on doing business. So let's say you're going to do business in California. You start business in Nevada. California charges you almost exactly the same in terms of qualification fees as you would if you're going to be a California corporation. And there's really no advantage today to doing anything out of state. I mean, as Rob said, Delaware law is very protective of major companies in terms of hostile takeovers, things like that. So most major companies are incorporated in Delaware because they want the protection. If there's a shareholder, it's not as protective of California as minority shareholders, things like that. But they're looking at it from a big company point of view. You do this, you're only doing business in California, you set up, say, in Nevada, you're going to get killed by, you're going to pay Nevada tax, you have to have an office in Nevada, you have to show that, now you're going to do business in California. It just doesn't make any sense at all.
For small business, I agree. It just stay, if you're here in California, stay in California. It's easier, especially with the LLCs. They've regulated the new act there that makes it a little bit more attractive and easier to take a look at. So it really depends on really what you want to do. But if you're going to be a small entrepreneur and you're just doing business primarily in California, just register in California.
A lot of people do that. However, there are different, you know, this is not a 1-minute answer. One question is, how quickly do you think you're going to sell off each partnership? Are you going to get rid of the LLC? But a lot of people do that. They form different LLCs for each entity. And you can have what's called a sole member LLC. So you can do that, yes.
Anybody else?
But what are the advantages and or disadvantages?
Well, the advantage is, as was alluded earlier, there are tax advantages to doing that. There are liability issues are huge. If it's an LLC, your liability is similar in the corporate way. Your liability is limited to the amount of that investment. And so you shield each, in effect, real property interest by setting up your different LLC.
The other advantage you have is, or do you have, you know, are you going to have different investors in each building? If you're going to have multiple investors, are all going to be in the same, or you're going to have different investors? So it really depends. I mean, Elliott's correct in saying you can't, that's not just a quick off-the-cuff answer, but it's something that can be explored to take a look at what you're going to do.
If I could follow, if you're going to have, I thought from your question, the same individual, in effect, was going to own all 10 buildings. But if you're going to have different investors in each one, it would be ludicrous not to have a different LLC for each one. Otherwise, you're going to have complicated questions of interest, who owns what, et cetera, and different management. So if you're in effect setting up different entities for each apartment building, you'd have a different LLC for each one.
a corporation has 700 years of Judeo-Christian legal history behind it. LLCs are about 30 years old. At first, a lot of lawyers were very nervous about LLCs because they didn't know, we had a statute on the books, but we had no case law. So we were nervous about how it was going to work. After the last few decades, I think we've worked most of it out and we could be more comfortable. Personally, this is my personal opinion, is I prefer the LLC in terms of corporate law. And that's because corporations, in order to maintain their limited liability, you have to have, the shareholders have to appoint a board of directors, and the directors have to appoint officers. Significant corporate actions have to be subjected to minutes. You have to document the action. Failing to do that, you run the risk of a creditor doing what's called piercing the corporate veil, getting at your personal assets for taking action outside what you thought was corporate action, but turns out wasn't. LLCs don't have any of those rules. LLCs are by default run by the owners of the LLC only. They don't have to document anything. So, my joke is that the best thing we do is nothing, right? So if there's nothing to do, you can't make a mistake, right? Yeah. So generally, for corporate standpoint, I prefer LLCs. It's not always the right answer, but generally I would prefer the LLC for that reason. Tax-wise, it gets much more complicated. And the thing is, they're both pass-through entities. The thing is, S corporations, if you have more than one partner, you have to split up everything in accordance with how much stock you own. You own 50% of stock, you get 50% of everything. LLCs, however, are creatures of a contract that you and your partner arrive at together. So you can actually say, you get all the interest income and I get all the dividend income. Unless the dividend arrives on a Thursday, in which case we split it. Anything you can think of, you can put in the LLC agreement. So it's a question of, do you want the simple pass-through of a corporation, or do you want as much flexibility as your mind can think up and be an LLC?
No, it's going to
Absolutely
change
not.
and get worse. In LA now, it used to be court reporters would be there in the courtroom, so you show up for a law and motion matter, someone would be there taking the transcripts so that when you go up on appeal, there'd be a record of what happened. Court reporters are no longer there, or if you want to have one, you got to pay for it in advance. Courts are closing left and right, primarily in LA. I just had a matter where I tried to file a motion last week, and we didn't get it. The earliest motion date we could get was May. So
You did better than I did. I got one in July.
Yeah. So budgetary constraints are not going to get any better, and the courts are going to be more and more strained, especially in LA. And people are going to resort more to arbitration and mediation to resolve their disputes.
Pretty complicated, but basically, your state of residence wants to tax you on all of your income wherever you earn it. What you often will do is say, but I'm paying, I may have had to file a California tax return, I had to include my New York income on it, but I also had to pay tax to New York. So the states have an agreement that say, we won't tax the same income twice. So if you paid $100 in California tax and $110 in New York tax on the same income, you get to take that $110 and apply it against your $100 in California, and you don't owe California anything. But it could be the other way, right? You owe $110 to California and you only paid $100 in New York, you might have to pay $10 to California. It's a little more complicated, but that's basically how it works.
I recommend in those cases you always carry a non-disclosure agreement with you, and you make them sign it. And if they say, I've had clients who call me and say the guy says he won't sign it, and I say, then he's telling you he's going to use that idea somewhere else. Go leave and go somewhere else.
Right,
So
but
I
are
would
those
tell
hard
you
to
use
hold
it.
up? Is it hard to hold that up in a court?
I mean, what the problem is that they're going to try to argue that they learned of the idea from somewhere else. It depends. I mean, we had a client who pitched an idea to Pepsi. So Pepsi signed an NDA, a non-disclosure agreement, but then they came out with a similar product. Suing Pepsi is not a great way. All it does is make the lawyer rich.
A lot of money.
It's very tough to do that. So I would tell you, I mean, there's some there's some sort of reality. How badly do you want the deal? And a lot of companies say we just don't sign NDAs exactly for that reason.
Right.
But it is, yes, they're difficult to enforce because someone's always going to say that. As was said earlier, you sue them, you're not going to go to court tomorrow and get a result. They're going to pay, you spend a lot of money on attorney's fees, but I would still carry it and push it and try to get it done.
Okay, last question.
Okay.
You have an employee that signs off that they have documented why they came in early, what they worked on, they left later.
No,
and
you don't you never let the employee decide what hours he or she is working. You tell them, if you want to get overtime, you have to put in a written form and we have to approve it. You don't let the employee say, I need to work early tomorrow because you're going to get caught in a hornet's nest.
So if it's agreed upon and the employee signs out and documents that, what they did and it's agreed upon, that releases the company from any problem.
Well, I mean, if you have a rule in the handbook and you have a memo to the employees that say that we don't allow overtime unless it's approved by your supervisor in writing, and the employee later claims overtime and he complains to the state, which is what he's going to do, then you say to the state, here's our policy, we sent him a memo, and he never had it approved. You should win.
Yeah.
But the state is very tough on these issues.
Well, litigators will frequently have more success piercing a corporate veil on a corporation than an LLC. I had a case where a guy claimed he had corporate formalities observed in a Nevada office. And when I did discovery, it turned out he hadn't followed the formalities, he didn't have minutes, couldn't even tell me what color the building was that he supposedly worked at. So a corporation is a lot easier to attack that. An LLC, like Rob was saying earlier, there are no formalities truly to observe. As long as you're paying your taxes every month and you haven't been suspended by the state of California, it's hard to pierce the corporate veil from a liability point of view of an LLC.
That international taxation is a matter of treaty law, right? Mexico is a sovereign country, so they can tax income, especially income from Mexican property, any way they want. But the United States and Mexico have a treaty, and they resolve questions like that. And as I recall, the question for real property, sale of real property, is that the state, and the state, I mean the country, where the property is located is the state that gets to tax it. So Mexico, if it has such a tax on gains from sales of property, Mexico is entitled to tax it. Now, the American rule is that you include all of your income from wherever earned worldwide. So you would have to include that gain on your U.S. return, but then you would say, but Mexico has taxed it. So you would get a foreign tax credit, it's called. I get to apply against my U.S. tax liability the taxes I've already paid to Mexico. And in that circumstance, that's exactly the way it should work, I think.
Thank you, all of you, for being here tonight. Shelley, thank you for having us up here.